Please, this is not industrial court. This is Federal High Court, Damaturu. Exhibit Order Chigbo 2. This is a magazine containing 8 rounds of live ammunition of 7.62 mm. Exhibit Order Chigbo 3. This is the extrajudicial statement of the defendant dated 16th October 2018, which the defendant recorded by himself. The prosecuting counsel closed his case and submitted that the defendant, having pleaded guilty before the court and with the evidence presented, urged the court to convict the defendant as to the offense he committed. This honorable court proceeded to inquire from the defendant whether the facts as stated by the prosecution witnesses and the exhibits tendered by before the court reflect the true position of the case, to which question the defendant answered in the positive. The defendant was convicted as charged. During allocations, the convict pleaded for the court to temper justice with mercy, being a family man that caters for younger ones, and that he is no longer with the Nigerian army. The case of the prosecution against the defendant has laid down in the 4-count charges that the defendant is standing trial for the offenses of possession of control of 1 fabricated pistol and ammunition of AK-47 firearm of 8 rounds of live ammunition of 7.62 mm without license, knowing fully it is restricted and prohibited firearm, with prohibited dealings and transferring the ammunition AK-47 firearm of 8 rounds of live ammunition of 7.62 mm and 1 fabricated pistol to Potiskum, Yobe State in contravention of the provisions of Section 28 of the Firearms Act, Cap F28, Laws of the Federation of Nigeria, 2004. The sections of the law the convict has contravened and the penalties thereof. As stated earlier, he's charged under Section 28, 1A sub 1, Section 28, 1B sub 3, Section 28B sub 2, Section 28C, V, respectively. Under Section 28, 1A sub A, if any person who contravenes the provisions, that provision shall be guilty of an offense and shall be liable on conviction. That section prohibits the possession and control of firearms and certain categories to a minimum sentence of 10 years. While for the second count, which is under Section 28, 1B sub 3, which prohibits any dealing in arms or ammunition to imprisonment for a term not exceeding 5 years. For the third count under Section 28B sub 2, which prohibits any dealing in arms or ammunition to imprisonment for a term not exceeding 5 years. And the last count under Section 28CV, C5, I meant, which deals with the sale or transfer of firearms or ammunition to a fine of 1,000 naira or imprisonment for a term of 2 years or to both such fine and imprisonment. The offense of unlawful possession of firearms requires the prosecution to establish the following ingredients. 1, that the defendant was found in possession of firearms. 2, that the firearms were within the meaning of the act. And 3, that the defendant had no license to possess the firearms. See the cases of the State versus Ola Dotun 2011 LPLR 3226, Okasha 2 versus the State 2016 LPLR 40611 at 1617, Dille versus the State 2016 LPLR 408321 at 32, and Momodo versus State 2008 All Federation Weekly Law Report Part 447 at 67. The main essential ingredient of the offense in count 1 prohibits the possession or control of firearms. Being in possession is the key. The firearm must be in the possession of the defendant. The question is, was the firearm found in the possession of the defendant? I note the testimony of the arresting officer in this case during cross-examination, as well as during examination in chief, as well as during cross-examination, wherein the PW1 stated that the defendant took us to the house behind Ohon Tesha in Potiskum. He was in possession of the key of the house. He opened it. That was how we discovered the said gun and live ammunition. This testimony establishes the fact that the defendant had constructive and actual possession of the exhibits. He led NDLEA officers to where the exhibits were kept, and it was recovered. Therefore, I strongly hold that there has been credible nexus between the defendant and the exhibits found in a house with a key held by the defendant, and the essential element of possession is conclusively established. So also the second element of the evidence to prove that it was indeed a firearm within the meaning of Section 2 of the Firearms Act, the PW1 expressly stated under examination in chief that he was the arresting officer and was the one who recovered the fabricated pistol, as well as one magazine containing 8 rounds of live ammunition of 7.62 mm. The exhibits to which PW2, the exhibit officer, tagged as exhibit number 93, 2018, and brought the pistol to court where it was tendered in evidence. The second element is established as well, as I so hold. On the third ingredient, even though it has been held that being in possession of a firearm without license is a strict liability offense, and that it is for the defendant to prove that his possession was lawful by producing his license. See Mohammed versus State 2019 LPLR 47044, 1 at 21 to 22, and Bille versus State Supra at 25 to 26. The defendant was a former soldier that has been dismissed from the Nigerian Army. The prosecution have convincingly established by credible evidence that the defendant was in possession of a firearm. Concomitantly, the defendant had the evidential burden to prove that the possession, which was proved, is lawful, and that the defendant failed to do so. Thereby, all the essential ingredients of the offenses has been proved as envisaged by Section 28 of the Firearms Act, Cap F28, Laws of the Federation of Nigeria, 2004, I so hold. Consequent upon my findings above, the defendant having pleaded guilty to all the 4 amended counts, and this honorable court having tried him summarily, pursuant to Section 33, sub 2 of the Federal High Court Enabling Act, Cap F12, Laws of the Federation of Nigeria, 2004, and in accordance with Section 28, sub 4 of the Firearms Act, which reads, a person charged with an offense under the provision of subsection 1A, B, or C of this section may be tried summarily in any part of Nigeria. In addition to the penalties prescribed in subsection 1 or 2 of the section 28 sub 1A, so 28(1)A sub 1 of the Firearms Act, Cap F28, Laws of the Federation of Nigeria, 2004. I therefore find the convict Odachibo guilty of the offenses as charged in count 1 and is hereby sentenced to 10 years imprisonment, being the minimum sentence the court can impose. For both count 2 and 3, the convict Odachibo is sentenced to 4 years imprisonment each. For count 4, the convict Odachibo is sentenced to 2 years imprisonment based on his plea of guilty on the 4 counts of the amended charges dated 30th June and filed 4th July 2022. The sentence shall be deemed to have commenced from 19th July 2022 when he was apprehended pursuant to Section 28 of the Administration of Criminal Justice Act 2015, rearranged and pleaded guilty before this honorable court. This is to serve as a punishment to you and a deterrent to others. This honorable court admonishes you to stay away from crime or any of its appearances. Essentially, the essence of punishment is to obtain a reformation in the subject. You are enjoined to stay true to your words and lead an exemplary life after serving your sentence. Meanwhile, this honorable court hereby orders as follows. The seized exhibits being a locally fabricated pistol and 8 rounds of live ammunition of 7.62 mm, admitted as exhibit Odachibo A and B respectively, is hereby confiscated and shall be forfeited to the federal government of Nigeria through the Inspector General of Police, portion to Section 28 sub 3 of the Firearms Act, Laws of the Federation of Nigeria 2004, which provides that any court of law may order the forfeiture of any firearm or ammunition to which the offense relates, and any such forfeited firearm or ammunition shall be disposed of in accordance with the instructions of the Inspector General of Police. This is my decision. The convict has 90 days within which to appeal both the conviction and sentence if he's not satisfied with same.
At court, please. Thank you, my lord, for this sound sentence. We are very grateful, my lord.
Okay. Yes, Mr. The convict, Mr. Odachibo.
Yes.
You have something to say to the court?
Yes, my lord. Good morning, my lord.
Good morning, sir.
I'm very grateful for today, for God to make it to be possible to hear this sentence today, my lord. What happened to my life today, I have not said that I'm not going to repeat back things that happened, my lord, but it's out of ignorance and foolishness, I will put it, stupidity in my life for this thing to occur to me, my lord. Because I'm a professional soldier, I have nothing to do with local God. That thing that they do, I think people that they brought that thing, I don't know anything about the local God. What makes me to answer?
Okay, Mr. Chibo.
My lord.
I think what you should do,
Yes.
because the trial is finished, that is why I said you can appeal. You can appeal. You have about 90 days, 3 months. You can appeal this. If you are not really satisfied, you can appeal.
Yes, my lord, I've heard you, but my lord, I have nothing for me to somebody that will help me for appeal or something like that, my lord. What makes me to answer my lord?
Mr. Chigbo, I will ask the station registrar of this court to get in touch with some lawyers who do pro bono services to get in touch with you.
Please, my lord, there's something I want to try. I'm trying to say, my lord. Please be patient and listen to me, my lord.
The thing is, you don't seem to understand. At this case, at this stage, there's nothing I can do more on it.
Okay, my lord.
There's nothing I can do because you have already been sentenced.
Yes, my lord.
The best I can do, that is why I said I'll talk to the station registrar, let him talk to some other lawyers again.
So, my lord, please, so you look up all the days for the day from my arrested and how my family there is suffering like more than now. Last week I have a call, he was on stroke now. There's no one there to help him. My brother that I have issue and what makes it to answer to this very case is my prosecutor counsel, means Ibrahim, the police officer. Is what I say this case have belonged. And the money that I give to them, 3.7 million naira, they said they will discharge this case. That's why they removed my casemate, 2 of my casemates, and only me for this very case. This is what I think.
Okay, I'll get a lawyer. I'll make sure that the station registrar gets a lawyer for you. That's what I can do for now, because we have other cases that is still pending.
Okay,
thank you, Mr. Chibo. Thank you, Mala Mustafa.
Thank you, my
correctional staff officers, thank you as well.
Thank you, my lord. Thank you, my lord.
Okay. Very good. The next case. Okay.
Thank you, sir.
Thank you. Thank you, gentlemen.
Thank you.
That number, FSC,
Help me for Mr. Paul Mustafa. I just wanted to, he doesn't seem to understand it. It's no longer in my attention. Yes, This other case is Bamala's case,
Yes,
Yeah.
madam.
the next case.
Yes,
That's
madam.
my.
Please, can somebody talk to him so that he can come quickly?
Okay.